Listen very carefully. For those navigating the complexities of U.S. visas and international travel, there's a critical development that demands your attention right now. You may have heard whispers, or perhaps even seen recent headlines about a visa bond. And let me be clear, this is not a rumor, and it's not a program that was merely proposed and then rescinded. The U.S. Visa Bond Pilot Program is very real, currently active, and profoundly impacting B1, B2 visa applicants from specific nations. Our channel name is US Citizenship and Visa, and we are here, as always, to guide you through these updates with clarity, calm, and facts. We understand the anxiety and confusion that new immigration policies can create, and our commitment is to provide you with the most accurate and practical information possible. Today, we need to talk about the U.S. Visa Bond Pilot Program, a policy that is currently in effect and impacting B1, B2 tourist and business visa applicants from a specific list of countries, requiring them to post a financial bond of up to $15,000. This is not a hypothetical scenario. This is happening now. This is big news for the families, students, and professionals it affects directly. Our goal today isn't to create panic, but to arm you with accurate, comprehensive knowledge. Because when you understand the rules, you worry less, and you can prepare properly for your journey. Let's break this down step by step, ensuring you have all the information to navigate this process successfully. First, let's establish exactly what we're talking about. The Visa Bond Pilot Program, or VBPP, is a measure implemented by the U.S. Department of State. It was initially put into place in December of 2020 under the previous administration, and, importantly, it has been extended and remains active today under the current administration. This is crucial because many believed it had been cancelled, which is not the case for the specific countries it targets. So, what is it? In essence, for certain B1, business, and B2, tourist, visa applicants from a designated list of countries, a U.S. consular officer may, at their discretion, require the applicant to post a refundable cash bond. This bond can range from $5,000 to $10,000 up to $15,000. It's a substantial sum. The full amount is returned to the traveler if they comply with the terms of their visa, specifically by departing the U.S. on or before the authorized date. Think of it as a significant financial guarantee to the U.S. government that you will adhere to your visa terms. Now, it's crucial to understand a few things right off the bat. This is not a universal requirement. It doesn't apply to every visa type, nor to every country. It's a targeted program. And it's important to differentiate this from regular visa application fees. Those are non-refundable processing charges. This bond is an additional financial requirement that serves as a security deposit, held by the U.S. government until your timely departure is confirmed. The legal authority for requiring such bonds is established under Section 221G of the Immigration and Nationality Act, INA, which grants consular officers discretion to require applicants to furnish such security as he may deem sufficient to ensure that such alien will depart from the United States upon the expiration of the time for which he was admitted or permitted to remain, or upon failure to maintain the status under which he was admitted or permitted to remain, or to maintain any other status into which the alien may be lawfully changed. So, why is this program in place? The U.S. government states that the primary purpose of the VBPP is to address and deter what they call high overstay rates from certain countries. An overstay occurs when a non-immigrant visitor remains in the United States beyond their authorized period of admission. Essentially, staying longer than permitted by their I-94 record, which is the official document that specifies your allowed period of stay, not necessarily the visa's expiration date. Under U.S. immigration law, specifically the Immigration and Nationality Act, there's a standing presumption that all individuals applying for a non-immigrant visa intend to immigrate permanently to the U.S. This is often referred to as the 214B presumption. It's then the applicant's burden to prove to the consular officer that they meet the criteria for the non-immigrant visa they're applying for, that they have a genuinely temporary purpose for their visit, strong ties to their home country, and a clear, demonstrable intent to depart the U.S. when their authorized stay ends. In recent years, the U.S. government has expressed increasing concern over the number of non-immigrant visitors who overstay their visas. These overstays can present significant challenges for various U.S. government functions, including border security, the allocation of social services, national security interests, and the overall integrity of the U.S. immigration system. When individuals overstay, it can lead to increased costs for law enforcement, a strain on community resources, and a perception that the immigration system is not being respected. The Visa Bond Pilot Program is essentially a tool designed to reinforce the temporary nature of B1, B2 visas for individuals coming from countries where historical data indicates a higher likelihood of overstaying. Typically, countries with a B1, B2 overstay rate of 10% or higher in the previous fiscal year. The substantial financial incentive, the return of a significant sum of money, is intended to strongly encourage timely departure and serve as a deterrent against unauthorized stays. It's a policy rooted deeply in data analysis regarding visa compliance, aiming to ensure that visitors honor their commitment to return home and uphold the principles of temporary visitation. Now, let's get to the critical question. Who does this program affect? The Visa Bond Pilot Program applies to B1, B2 visa applicants from a specific list of countries identified by the Department of State. This list is subject to change based on updated overstay data and policy reviews, and it's always best to check the most current information from official sources. This fluid nature makes staying updated paramount. However, based on the recent continuation and publicly available reports, the list of countries that have been subject to this program include nations such as Kyrgyzstan, Tajikistan, Turkmenistan, Bhutan, Laos, Mongolia, Liberia, Burkina Faso, Djibouti, Eritrea, Gambia, Haiti, Mauritania, Papua New Guinea, and São Tomé and Príncipe. Again, this is not an exhaustive or permanently fixed list. It's essential to always check the most current information directly from the U.S. Department of State website, travel.state.gov, and the website of the specific U.S. embassy or consulate in your country for the definitive list and specific details. Do not rely on outdated news articles or social media posts for this critical information. Beyond simply being from one of these countries, the decision to require a bond is made on a case-by-case basis by the consular officer during your visa interview. They conduct a thorough assessment of your individual circumstances, looking for ties to home versus ties to the U.S. Factors that might lead a consular officer to exercise their discretion and require a bond include lack of strong economic ties, unstable employment, low income, or lack of significant property ownership in your home country, vague travel plans, unclear itinerary, insufficient funds for the trip, or inability to articulate the purpose of visit. Previous immigration violations. Any history of overstaying visas in the U.S. or other countries, or previous visa denials. Lack of strong family ties. No immediate family, spouse, children remaining in your home country. Age and education. For younger single applicants with limited education and job prospects in their home country, this presumption of immigrant intent can be stronger. It's equally important to know who this program does not affect. It does not apply to U.S. citizens or lawful permanent residents. It does not apply to applicants for other non-immigrant visa categories, such as student visas, F1, temporary work visas, H1B, L1, O1, or exchange visitor visas, J1, unless there is a separate, distinct policy specifically targeting those categories, which is not the case for this VBPP. And crucially, it does not apply to B1, B2 applicants from countries not on the designated list. So if you are applying for a B1 or B2 visa and are a national of one of these designated countries, you must be prepared for the possibility of a bond requirement. It's not a certainty, but it's a very real possibility that you must factor into your planning. Understanding the how of the Visa Bond Pilot Program is crucial for anyone potentially affected. Let's walk through the typical steps of this process, from your interview to the eventual refund of your bond. 1. During the visa interview. If you are a B1, B2 applicant from one of the designated countries, the consular officer will conduct your interview as usual. This interview is your opportunity to convince them of your temporary intent. During their assessment, if they have concerns about your intent to return to your home country, despite your documentation and testimony, they may inform you that your visa approval is conditional upon the posting of a bond. They will clearly specify the bond amount, either $5,000, $10,000, or $15,000. Depending on their individual assessment of your risk level. At this point, it's not a negotiation. You either accept the condition and proceed with the bond, or your visa application will likely be denied under INA 214B. 2. Posting the bond. If a bond is required, the consular officer will provide you with precise, written instructions on how to pay it. This is typically done through a designated financial institution in the United States, or sometimes directly to the Department of Homeland Security, DHS, or Customs and Border Protection, CBP. The instructions will detail the payment method, which could be a certified check, money order, or electronic transfer to a specific U.S. government account. It's vital to follow these instructions precisely, as any errors could significantly delay your visa issuance or complicate your bond refund later. The bond must be successfully posted and verified by the relevant U.S. agency before your visa can be issued. This means you will need to arrange for these funds, often from abroad, which can present a significant logistical and financial challenge for many applicants and their families. Ensure you get and keep copies of all payment receipts and confirmations. 3. Travel to the U.S. and departure. Once the bond is posted and your visa is issued, you can proceed with your travel to the U.S. When you arrive at a U.S. port of entry, airport, seaport, or land border, a CBP officer will admit you and determine your authorized length of stay. This authorized period will be electronically recorded on your I-94 arrival-departure record. You can access your I-94 online via the CBP website, i94.cbp.dhs.gov. This is your official departure date, and it is absolutely essential that you depart the U.S. on or before this exact date. Do not confuse your visa validity period with your authorized period of stay. The I-94 is the definitive document for your departure deadline. 4. Proving departure. To ensure your bond is refunded, you must actively prove your timely departure. This requires meticulous record-keeping. You should keep your original boarding pass for your flight or other mode of transportation out of the U.S., copies of your e-ticket or travel itinerary, photos of any exit stamps in your passport, though many countries, including the U.S., no longer routinely stamp passports upon exit, any other official documentation confirming your departure date and time. It's often recommended to proactively contact CBP or the Department of State after your departure to confirm your exit has been registered in their system and to initiate the bond refund process. Waiting for them to contact you can lead to significant delays. 5. The bond refund. The bond is designed to be fully refundable. Once your timely departure is verified by the U.S. government, which means they've confirmed you left on or before your I-94 date, the process for refunding the bond begins. This is not an instantaneous process and can take several weeks or even months to complete, so patience is key. You will typically need to submit your proof of departure, usually to the U.S. Embassy or consulate where your visa was issued, or directly to the specific U.S. agency that collected the bond. They will then process the return of your funds to the original payer, so ensure the contact and bank details are accurate. What happens if you overstay? This is the critical part and the primary reason for the bond. If you fail to depart the U.S. by your authorized date, as indicated on your I-94, the bond will be immediately forfeited to the U.S. government. You will not get your money back. Furthermore, overstaying a visa has severe and long-lasting consequences for your future eligibility for any U.S. visas, both non-immigrant and immigrant, and can result in significant bars to re-entry to the United States. For example, an overstay of more than 180 days but less than 1 year can result in a 3-year bar from re-entering the U.S., while an overstay of 1 year or more can result in a 10-year bar. This is why strict compliance is paramount, and the bond serves as such a strong incentive to deter overstays. The implementation and continuation of this visa bond pilot program carry significant implications, especially for those in the affected countries. 1. Financial burden. The most immediate impact is, of course, the substantial financial burden. A $5,000, $10,000, or $15,000 bond is a considerable sum for most individuals and families, representing a major financial commitment. It acts as a potential barrier to legitimate travel for business, tourism, or visiting family, as many simply may not have access to this much disposable capital. This can inadvertently penalize individuals who have every intention of returning home. 2. Perception and trust. For many applicants, particularly those who have no intention of overstaying and who demonstrate strong ties to their home country, this requirement can feel like a profound lack of trust from the U.S. government. It can add stress, anxiety, and even a sense of being unwelcome to an already meticulous and often nerve-wracking visa application process, potentially souring the perception of U.S. travel and diplomatic relations. 3. Impact on tourism, business, and cultural exchange. While the program aims to target countries with high overstay rates, it undeniably could deter legitimate business travelers, tourists, students planning short visits, and those seeking medical treatment from these nations. This reduction in travel could impact cultural exchange, educational collaborations, trade, and local economies that rely on international visitors, creating unintended, broader consequences. So, what is our comprehensive advice at US Citizenship and Visa if you are potentially affected by this program? 1. Be prepared for the possibility, mentally and financially. If you are a national of one of the designated countries and applying for a B1, B2 visa, go into your interview knowing that a bond could be required. Mentally and financially prepare for this. Discuss this possibility with your family. If paying the bond is not an option for you or a sponsoring family member, then proceeding with the visa application may not be advisable, as you might face an inevitable denial if a bond is mandated. 2. Strategically strengthen your case for return. Your primary objective at the visa interview is to overcome the presumption of immigrant intent. Always present the strongest possible evidence of your ties to your home country. This includes original property deeds, utility bills in your name, certificates of marriage, birth certificates of dependents, detailed employer letters confirming your job, salary, and approved leave,
recent bank statements showing significant savings, any other documentation that clearly demonstrates your deep roots and compelling reasons to return. The stronger and more compelling your evidence of temporary intent, the less likely a consular officer might feel the need to require a bond. 3. Embrace meticulous record-keeping. This is non-negotiable for success in the VBPP. From the moment you apply, create a dedicated Visa Bond folder, physical and/or digital. Keep copies of everything: your visa application, all supporting documents, the instructions for paying the bond, all payment receipts and confirmations, your issued visa, your travel itinerary, and most importantly, your boarding passes and any other proof of your timely departure. This documentation will be absolutely vital for your bond refund process. 4. Depart on time, every time. Check your I-94 online. This cannot be stressed enough. If you are granted a visa with a bond requirement, ensure you leave the U.S. before your I-94 expiration date. Set multiple reminders on your phone, calendar, and with family members. Crucially, always check your I-94 record online, i94.cbp.dhs.gov, as soon as you enter the U.S. to confirm your authorized stay and departure date. This is the only official document for your departure deadline. Do not rely solely on the date stamped in your passport or the visa validity date. 5. Consult official sources exclusively. Always, always, always refer to the official U.S. Department of State website, travel.state.gov, and the website of the specific U.S. Embassy or consulate in your country for the most up-to-date and accurate information regarding the Visa Bond Pilot Program, the current list of affected countries, and the precise procedures. Policies can be updated without immediate broad announcement, and unofficial sources, social media, or outdated forums can be misleading and lead to costly mistakes. 6. Consider legal counsel if complex or challenged. If your situation is particularly complex, for example, previous visa denial, unique family circumstances, or if you encounter difficulties during the application process, if a bond is unexpectedly mandated, or if you face issues with your bond refund, consulting with an experienced immigration attorney can provide invaluable personalized guidance. They can help you understand your rights, prepare your documentation, and navigate any challenges that arise. The world of immigration and international travel is constantly evolving. The Visa Bond Pilot Program is a clear example of how critical it is to stay informed about even seemingly niche policies, as they can have a direct and substantial impact on your travel plans and your financial well-being. At U.S. Citizenship and Visa, our mission is to cut through the confusion
and provide you with clear, actionable information. We understand that policies like these can cause concern, anxiety, and even frustration. But by understanding them fully, you gain confidence and control over your situation. Knowledge empowers you to make informed decisions and prepare effectively. If this information felt helpful and provided you with the clarity you needed, please give this video a like. Sharing it with others who might be affected is incredibly valuable, as it helps accurate information reach those who need it most, preventing costly errors and unnecessary stress. And if you want to stay consistently updated on all things U.S. immigration, visa news, and travel changes, make sure you subscribe to our channel. We'll continue to be here, calmly breaking down complex issues so you always know what's coming and what it means for you. Immigration journeys take courage, resilience, and a deep commitment to staying informed. Wherever you are in your process, applying, preparing to travel, or planning for the future, we at US Citizenship and Visa are proud of you for taking these proactive steps to educate yourself and move forward with care. Thank you for spending this time with us today. Stay safe, stay organized, and stay hopeful.